federal domain. Provinces can't make any law. Now, surely a province is entitled to say, well, sir,
we need more judges.
No, not we need more judges. That a high court, it may be a matter relating to the federation, but it also relates to a province. How can you relate law over there as act of parliament, read it with entry 58 and just wipe us out of the picture? No, but वकील साहब,
मैं इस पे आगे आने लगा हूँ।
तरीन साहब, इसमें एक मुश्किलात है ना। अब सवाल ये उठेगा, अगर दोनों आए तो फिर कंकरेंस है, कंकरेंस है तो फिर पैरामाउंटसी है। देखिए, जो क्वेश्चन दैट माय बात सुन लें, द क्वेश्चन दैट माय लर्नेड कॉलीग पुट टू यू, वन साइज फिट्स ऑल नहीं चल सकता यहाँ पे। यूज ऑफ द वर्ड लॉ कैन हैव सो मेनी शेड्स ऑफ मीनिंग। तो आप जरा
इसको हम एड्रेस कर लेते हैं, इसको इट्स इजीली एड्रेस इसको कर लेते हैं।
मैं आई एम जस्ट पॉइंटिंग आउट द डिफिकल्टी।
I thought about it that why can't mean an act of provincial assembly, but that need not detain us for the purpose of Article 191, because there the Supreme Court is exclusively outside of this.
Yes.
So therefore, for the purposes of 191, there is a confusion here. I thought about it, but then I stopped thinking about it for that matter, because 191 के लिए relevant नहीं था. But in any way, in any event, it would be an act of parliament, or.
But why don't you say it is intentional by the framers of the Constitution that one place it is by act of parliament, surely there it could not be by law. So we are agreeable there, I hope. And the other one, the parliament kept the door open, whether it would be parliament itself or it would be the provincial assembly, without fixing it, because maybe the framers of the Constitution wanted to make the Constitution a living, breathing organism which can, depending on the situation at that relevant time, and if they have put Act of Parliament, then it would have fixed it and Provincial Assembly would have gone away. Or if they have put Parliament or Provincial Assembly, they may not have wanted to do so. So sometimes ambiguity is intentional. It is not that they made a mistake or didn't think about it. I would consider that if they use the word law there, we don't need to address that in this case, but it is the only thing which comes out clearly is that the first one is fixed by the Parliament and the other one by law, which could surely not include judge-made law.
And
I would think that would be a stretch if we say, no, it could also include judge-made law.
And
I don't know.
If I may, it should surely be an act. We can debate which assembly or the Parliament, that we can park it aside for the purposes of these proceedings. But what it surely does is that for the purposes of Article 191, an Act of Parliament cannot be excluded.
It's the context which has to be seen. The context is relevant. I think the language is used in context. The words should don't mean, the same words can mean very different things used in different contexts.
So, the point that I'm trying to make through this is that an Act of Parliament is included, is covered in the meaning of term law in 191. 191. Now, before
Attorney General, you were just referring to 192. And you said the word law is used here, but देखें उसका context क्या है? The High Court shall consist of a Chief Justice and so many judges as may be determined by law. ठीक है? अच्छा, अब उसको आगे क्या उन्होंने qualify कैसे किया? Until so determined. इसमें क्लियरली इंटेंशन है कि जी लेजिस्लेटिव कॉम्पिटेंस वो दे रहे हैं कि आप जब तक वो लॉ नहीं बनाते तो प्रेसिडेंट डिटरमिन करें. There is no such phraseology used in 191. It doesn't say until such law is made.
There is a reason for that.
Yes.
The reason is because in both 1962 and 72 the identical language appeared. And when 93 Constitution commenced, we already had the rules. So there was no reason for anyone to determine anything because there was already something in existence.
No. So obviously,
unlike this situation,
ये कहा जा सकता था ना, अगर ये intention थी कि जी the Supreme Court may make rules regarding regulation of procedure and practice until law is made or a law is promulgated. ठीक है? اس میں آپ لیجسلیٹو کمپٹنس کنفر کر رہے ہوتے کہ جی سپریم کورٹ اگر رولز بنا بھی لیتی ہے تو آپ اگر قانون بنا دیتے ہیں تو اٹ وڈ اوور رائڈ دوز رولز. Now that intention is neither explicit nor implicit in the language of 191.
My lord, my respectful submission is that it is not so.
جہاں ان کی انٹینشن تھی کہ جی لیجسلیٹو کمپٹنس گرانٹ کرنے کی, وہاں انہوں نے لیجسلیٹو کمپٹنس ایکسپریسلی گرانٹ کی ہے.
My lord, I'm going to come to that, but let me first address the question that you had previously raised, and let me just deal with it, because when we look at the term law, we have to give it some meaning. Some meaning to it. I have submitted that there could be two meanings to it. One meaning is an act, other meaning is a binding precedent. I'm going to deal with it when I address the question of convention. But let me first take care of the 1956 rules being existing law, and then proceed with it.
Do you have attached the rule 1956 in your paper book, 1956 rules?
My lord, this may kindly be recorded, my lord. This is something that I thought about later, so this may kindly be noted. Now, clause 7 of article 268 does include within its meaning rules, bylaws, regulations as existing laws. And then clause 1 of article 268 tells us how they shall be dealt with under the new constitution. I'll just read out 268 clause 1 and then take your lordships back to 191 and then the rules of 1980. Clause 1 of article 268, it says, except as provided by this article, all existing laws shall, subject to the Constitution, continue in force so far as applicable and with necessary adaptations until altered, repealed or amended by the appropriate legislature. Identical language in 270AA6, which deals with anything and everything that had happened prior to omission of or concurrent legislative list.
Sorry,
after the 18th
I'm not following it. Are you saying that Article 268(1) saves laws which
And
existing laws which it goes on to define in subclause 7, but specifically excludes decisions of the Supreme Court or the High Court? Are you saying that?
No, what I'm saying
But
is,
this definition of law does not say and decisions.
मैं अभी उस पे आता हूँ सर. मैं यहाँ पे ये कह रहा हूँ कि जो existing laws थे उनको save किया.
But when
Granted.
we're using the term law, because sometimes you say it includes decisions. So, but this article does not
This is
mention.
independent of my earlier submission. मैं यहाँ पे उस point को address कर रहा हूँ जहाँ पे my lord की observation थी.
नहीं मैं वो बातें नहीं मैं आपसे सवाल स्टैंडर्ड
वो तो नहीं
सवाल
होगा,
कर रहा हूँ. मैं ये कह रहा हूँ कि does this mean that this is the starting point and we are not, the courts are free of earlier judgments because existing laws does not specifically mention decisions of the superior courts or of any courts?
उसमें my lord perhaps 189 का effect
No, perhaps
आएगा.
नहीं, मगर
189 का
अगर आपका
effect so
लॉ
long
आप
as
उसको एक्सटेंडेड मीनिंग दे रहे हैं तो यहाँ आप उसको रिस्ट्रिक्टेड मीनिंग दे रहे हैं.
provisions which survive will
Existing
have to
laws
be
की
read.
definition दी हुई है AG साहब.
The provisions
Existing
which
laws
survive.
की
Clause
definition.
7.
जजमेंट्स का तस्करा नहीं आ रहा है ना.
नहीं आ रहा ना, उस 7 में definition
उसमें-
पढ़ लीजिए
उसमें ये
आप.
होगा definition.
Existing laws की
जी
सब article 7 पढ़ लें.
जी.
In this article, existing laws means
All laws including ordinances, orders in council, orders, rules, bylaws, regulations and letters patent
शायद इसलिए भी
constituting
ना
a high
कि
court and any notification.
Attorney General, this is a saving clause, so they could not have referred to the judgments. It is a saving clause, could only deal with laws.
Laws and so long as those laws continue, the effects of the
Why are we
continue.
categorizing it as a saving clause?
My lord,
No, tell me from the text why are you categorizing it as a saving clause?
my lord, this is giving continuance to the laws which were in field.
No, but
because
if you read it with subclause 1,
Ji.
it is nothing saving about it.
no, what it is doing is, it is in order to ensure the continuity of system. it is
part of the
permitting those laws to
देखिए, if that
continue
is the
till such
argument,
time.
if that is the argument, then continuity of the system surely requires judgments to be sustained as well.
मैं उसकी जरा थोड़ी सी ये submission complete करूँ, ये confusion clear हो जाएगी.
Okay.
Let me just complete my submission. My lord, my submission, and then let me just now state what my submission is before I come to explaining it. My submission is that the term law used in 191 cannot possibly include 1956 rules. And I say this because if
Existing laws did not include.
the term law in 191 as used in Article 199 cannot include 1956 rules. This is the observation, this is an observation made by my Lord Justice.
Kindly repeat that, I'm missing it.
The term law used in Article 191 does not include
1956
an existing law, which is to say the rules of 1956, the Supreme Court rules of 1956.
Does not include the 1956 rules.
Why? Now, if we turn to clause 1 of Article 268, and if I may reread it.
Before going to that, if you read Article 75, Article 75, please read that. That is, I think it is relevant, and specifically sub-Article 3.
Altered in 2000.
Yeah, देख ले इसमें what is law? It has been defined.
Law को वो कह रहा है कि जब वो act
जब पार्लियामेंट आप पढ़ लेगा.
जी मैं उस
Oh, this
मैं आ जाऊँगा.
under sub-Article 3, it is said when the president has assented to, it is deemed to a bill, it shall become law and be called an act of
Parliament.
Shura.
Yes.
So, if it is assented by president, the law is an act of the parliament.
मैं सिर्फ ये तो मैं ऐसी एट द आउटसेट में बता चुका हूँ. मैं इस वक्त उस क्वेश्चन को एड्रेस कर रहा हूँ जो ये आया था कि जी एग्जिस्टिंग लॉ, बिकॉज 56 के रूल्स एग्जिस्टिंग लॉ हैं एंड 191 के नीचे वो लॉ की उसमें आ जाएंगे, एंड देयरफॉर जो हमने सुप्रीम कोर्ट ने रूल्स बनाए हैं they are perfectly all right, they could only be.
Mr. Attorney General, if I have understood you correctly, you say the term law used in Article 191 does not include the 1956 rules.
And not include 1956 rules as existing law,
No, but my question to you is, are the Supreme Court rules 1980 currently framed, are they law?
No, not within the meaning of 191. No,
Ji?
not within the meaning of 191. And let me please try to explain it.
I'm saying.
इसको explain कर लेने दे ताकि at least वो question address हो जाए.
नहीं, but one word answer is no, they are not law.
They cannot be treated as.
Obviously,
they
they're
cannot
not
be
law
treated.
within the meaning of 191 because otherwise the argument is circular. How can this?
Yes,
I mean,
yes, my lord is right.
but
My lord can complete what
leaving
you're
that
saying.
aside,
Yes,
no,
that's
no,
right.
leaving that aside, I'm still curious. Are the rules, forget 190, the use of word law in 191. My question is more general. Are the Supreme Court rules 1980 law or not?
The Supreme Court rules 1980 regulating practice and procedure cannot be called law within the meaning of 191. So
But
to that
isn't
extent,
it
doesn't
law
answer
under
my
the
question.
Constitution?
That doesn't
Under
answer.
the Constitution, say says not by or under the Constitution. This is something mandated under the Constitution. It derives its.
Are your rules of are your rules of business made under Article 99? Are they law?
मुझे एक चीज
हाँ मुझे बताइए.
मुझे एक चीज
अरे Attorney General साहब,
एक
you have
चीज
made
जरा
a
मुझे
very
address कर लेने दें.
extraordinary statement, which are the rules of business made under Article 99 law or not?
My lord, my submission is that in the
Give me a
broader
straight
sense,
answer
in
to
a
your-
broader sense, yes, they would have the
Are the-
meaning
are
of
the
law for the
rules-
purposes of regulating
Are
the
the
business of
rules
federal
of the
government. Yes.
Are the
Yes,
rules
yes,
of the
yes.
National Assembly rules of
Yes.
procedure made
Yes.
under Article
Yes.
60?
My answer to your question was that for the purposes of 191,
That
they
was
cannot be
not,
called.
but that was not my question.
Generally speaking, yes.
Vakil Saab, that was not my question.
Sir, मैंने कहा generally speaking, yes.
Generally speaking नहीं, एक
But-
generic question आपसे
मैं अभी तो एड्रेस कर रहा हूँ और चीज. अभी मैं एड्रेस ही और चीज कर रहा हूँ. अब आप उसको और
Constitution
ले जाएं.
ने लॉ रूल मेकिंग पावर दी है एग्जीक्यूटिव को भी, लेजिस्लेचर को भी, सुप्रीम कोर्ट को.
Absolutely.
सवाल ये है जो एग्जीक्यूटिव ने अपने रूल्स ऑफ बिजनेस बनाए हैं इन एक्सरसाइज ऑफ पावर्स अंडर द कॉन्स्टिट्यूशन, आर दे लॉ?
Yes.
Yes.
First they are law.
जो लेजिस्लेचर ने अपने रूल्स ऑफ बिजनेस बनाए हैं, आर दे लॉ? So if they are law, then why are the rules of business, rules of procedure framed by the Supreme Court in exercise of powers granted by the Constitution, the same powers which the legislature has, the same powers which has the executive has, not law?
इसी को ही मैं एड्रेस करना चाह रहा
जी करें.
आपने कहा कि जो हमारे रूल्स थे 1956 के
56 को जो 80 की बात कर
उसको नहीं, उसको अगर हम एक तरफ रख दे तो एटलीस्ट वी कैन एड्रेस, वी कैन टेक केयर ऑफ, एंड आई नीड नॉट मेक एनी फर्दर सबमिशंस ऑन देम बीइंग एग्जिस्टिंग लॉ एंड thus the term law including those meaning those 1956 rules. If that is accepted, I need not make any submission.
I'm not accepting. What I'm saying is आप 80 के rules की बात करें, वो law हैं या नहीं है?
मुझे आप पहले वो एड्रेस तो करने दे, अब आप उसको एक्सेप्ट नहीं कर रहे, मुझे सबमिशन उस पे कंप्लीट तो करने दें.
If I've understood you correctly, you say 1980 के जो rules हैं वो under the term law आते हैं. However, in the context of 191, you cannot consider them as law. Because then the entire process, then there will be contradiction within the letter of Article 181.
Absolutely, my lord. And यही contradiction है जो उस argument में है या उस point में है कि जी वो because existing laws में आते थे.
वकील साहब एक जरा kindly Attorney General sir, you're making, speaking for myself, an extraordinary submission, so I want to be sure I understand it. Now, you say 1956 rules are not existing law. But you say that the Supreme Court rules of 1980 are law in the broader sense of the term, right?
Please rephrase me. Let me rephrase myself. What I said was that they would be existing laws. They would be existing laws covered under 268(7), but they cannot be termed or treated as law within the meaning of term law used in 191. That's what I'm saying.
मैं समझ गया हूँ बात, but मैं still the reason I'm asking this question is that Rule 1, Sub-Rule 2 of the Supreme Court rules, which you say is law, specifically says the Supreme Court rules 1956 are hereby revoked.
Yes.
So both have to be law. Both have to be law. Otherwise, in 1980, the Supreme Court could have said there are no laws. The Supreme Court rules of 1956 never existed. They ceased to exist when this Constitution came into being. We don't need to revoke them.
So what then this means is, मैं आपकी बात तो समझ गया हूँ, बेटा.
नहीं, आप मेरी सबमिशन तो जो आप फरमा रहे हैं, मैं उसको समझने की कोशिश कर रहा हूँ.
मैं ये कह रहा हूँ.
अरे बात तो सुनिए ना. आपने जो आर्टिकल 268 पढ़ा, क्लॉज 1 पढ़ा, that says subject to Constitution. And so it is possible, is it not, that the 1956 rules were existing law.
Yes.
But the power to amend existing law within the meaning of clause 1, article 268 was subject to the Constitution. The rules of 1956 were the rules that applied in terms of the rule-making power, not law, rule-making power of article 191, and therefore the same shouldn't say problem, issue I would say, in relation to any legislation affecting, amending, restricting, repealing, whatever, the 1956 rules applied as it does now in the context of this proposition before us, this act versus the 1980 rules, exactly the same position applied. Would you agree with that?
Yes. Yes.
Yes.
Yes.
Thank you.
And that is why,
Thank you.
I would just conclude by this submission by saying that when existing laws
आपने जो पूरी अपनी बहस शुरू की है, वो आपने किसी और बेसिस पे शुरू किया. आप अपने आर्गुमेंट्स करते तो ये सारे मसले आपके खड़े नहीं होते. But sometimes it is not very easy to give a yes/no answer. It was like the young, on a lighter note, माहौल भी जरा ठंडा रखते हैं.
अच्छी बात है.
On a lighter note, a lawyer was battering a lady during cross-examination. the husband representing the lady, and he said, "Have you stopped beating your wife? Answer yes or no." So keep it things light and move ahead.
So I'll just conclude my submission by saying that the 1980 rules or the 1956 rules, though they were existing laws when the Constitution came in, but saying that they were the law within the meaning of Article 191 would be a contradiction.
Okay, can I ask a question?
आगे चलता हूँ.
ये एक सवाल सुन लें कि आप ये कह रहे हैं कि वैसे तो the rules are law, but for the purposes of 191 they are not law. Now wherever the word law has been used, what principle of interpretation will be applied to see whether these rules or any other rules will be applicable there in the term law or not? The reason I ask this question is that the first day, my question to you was that if subject to the Constitution and the law meant law just an act of Parliament to the exclusion of everything else, then maybe the word law was not the right word. So when we look at the word law, we have to read something more than just an act of Parliament. So the act of Parliament is there, but other things are there. Now you are saying उसमें से आप ये rules निकाल लें because यहाँ rules नहीं apply होंगे, then in some other provision rules डाल दें because वहाँ rules apply होंगे. So there doesn't appear to be any principle of law that one is following on the basis of which one would determine where to use what part of law.
इसमें learned Attorney General, since this discussion is in the context of Article 191, can we construe Article 191 that the rules may be made by the Supreme Court subject to the rules that it will make? This is the simple question. You see, it automatically excludes the rules that will be made.
My Lord Justice,
because it is in the context of Article 191.
एक बात AG साहब और भी है, what I understand from the questions of the learned colleagues, that is subject to the Constitution and law. Obviously the Supreme Court may make the rules. Once the rules have been framed, and maybe this may be included in the definition of law, but whether there is any sunset clause after making rules by the Supreme Court, the word law has become redundant. What is the purpose then?
Yes.
If we are talking on it, then once the Supreme Court has made the rules, that has become the end of the story, and they cannot make further rules.
Redundancy.
And the redundancy attribute हो रही है ना, अगर हम उसको करते हैं कि Supreme Court rule बना सकता है, Supreme Court has made up the rules. Then what is the purpose of the law used in the Article 191? Because there is no sunset clause. After making rules, obviously it will be a sunset clause for that. जैसे आपने नीचे पढ़ा है ना कि वो हाई कोर्ट के लिए कि जब तक उसकी प्रेसिडेंट साहब नहीं करते तो वहाँ sunset clause है, unless such time the president make the rules.
So as I see it, the word law is evergreen in 191, and secondly, it might entail other instruments, but what I'm concerned with right now is the Act of the Parliament is also there, and that is enough for me to go forward.
Yes. So
are you going to answer my question? क्योंकि वो तो रह गया.
According to you,
I owe an answer to a lady.
okay, according to you, once the rules have been framed, in exercise of constitutional jurisdiction that 191 confers, they are law. Number one. Number two, because of the language of 191, it is an exclusive power given to the Supreme Court to frame rules.
Where does the
Subject to the Supreme Court may make framed rules.
Yes.
So the Supreme Court frame rules.
And subject to the law and the
So
Constitution.
what you're saying is, once this law has been made or framed by the Supreme Court, can a subsequent act of the Parliament trump it or modify it or render it redundant?
My Lord, there is no fetter, there is no restriction under 191 on Parliament's power to make any amendments, barring one, which is that it should not in any way undermine independence of
वो
judiciary.
तो standard test
वो
लगेगा ना,
extended test है, उसके अलावा there is nothing in the language of 191.
अगर मैं आपकी बात समझ पाया हूँ.
So if you invert
Your Ladyship, my Lord is not letting me answer the question.
If you invert the equation, the same thing can be done by the Parliament, the same thing can be done by the Supreme Court. Both can make the law as far as practice and procedure is concerned. So you say there is no fetter on the power of the Parliament to amend the rules that the Supreme Court makes.
Yes.
So if you invert the equation, then there is no fetter on the power of the Supreme Court to amend the law that the Parliament makes.
But then it's subject to.
Subject to what?
Law.
Subject to law, law वही है ना, आप कह रहे हैं ये भी law है, वो भी law है.
No.
So then there is an interaction of two laws.
The interaction.
Or a conflict of two laws.
There can't be interaction to two laws. In that broader sense, Constitution also is a positive law. We can't possibly say that.
The Parliament that makes the law that you're saying subsequent.
Parliament is the lawgiver, my Lord. Let's acknowledge it.
Hold on. It stands on a higher pedestal.
Parliament is the lawgiver.
ये बताइए
तो सेपरेशन के ऊपर जब बात करनी है, मैं वहां तक अगर पहुंचा तो यही बात करूंगा कि
लैंड अटॉर्नी जनरल ये बताइए,
अगर ये आपका आर्गुमेंट मान लिया जाए तो ये बता दें कि 191 का मकसद क्या था?
लैंड अटॉर्नी जनरल ये बताइए, if under the obligation under the convention, the Parliament makes a law that all jail appeals shall be fixed within 1 week from the day they are presented, will they not prevail over any of the rules made by the Supreme Court?
Yes.
And those rules will then be subject to this law.
Yes. That's right, my Lord.
And independence of judiciary is not affected.
And independence of judiciary is not getting affected by this. Access of justice is being advanced.
If your argument is accepted in toto, then what was the fun to insert this 191, Article 119 in the Constitution?
I didn't get the question, my Lord.
My question is that what was the fun to insert 191 in the Constitution if it was not the intent of the legislator that the authority has been given to the Supreme Court to frame rules?
Yes, the authority has been given, but with a preface, with something which it is subject to, which is the Constitution and the law.
It doesn't mean anything. If it was exclusive within the domain of the legislator, then this 191, that is of no use.
How so? I didn't.
What is the purpose of making these rules? To give effect to the Constitution and law.
And to have the court function, and of course, that's the purpose.
Because the Constitution and law is not so exhaustive, that's why rules are framed to give effect to the Act and the Constitution.
May I answer the question first?
Your Ladyship, the term law as used in the Constitution, and as it has, you have noticed, it has been used at various instances. In addition to as an Act of Parliament, where term specifically Act of Parliament has been used, we will look at the provision, and from the provision we'll call out what that term then implies, in the sense that, as I've submitted, which source of law is it referring to, or which source of law does it capture, whether it is exclusively, and the context of that provision be termed as an act of the appropriate legislature, or would it also include how the courts have expounded that law, and that law is also applied insofar as that proceeding is concerned. But for the purposes of Article 191, my respectful submission is that an Act of Parliament as law cannot be excluded.
I accept your argument that it cannot be excluded. The question is that if it can't be just an Act of Parliament, it has to be something more. So when you argue on the strength that just look at it as an Act of Parliament, because it's included, it's enough to proceed forward and say, yahan se competence dekhte hain, that's where I have difficulty. That when it's just an Act of Parliament, then there is a definite word used that by an Act of Parliament. Here the word is law, so it will clearly mean more than just an Act of Parliament. Why are you reading it to the exclusion of everything else?
And Mr. Attorney General, I see it this way, that we are reading it as an exclusion to the other thing because the question is of competence.
Yes.
So I'm not concerned about the other instruments, I'm concerned about the main instrument, that's the Act of the Parliament.
So, and we'd be concerned perhaps with the other instrument, if I may just complete, with the other instrument, if there is any conflict between this instrument and some other principle where the court may have lay it down and I'll address that.
If I may have a clarification, if I understand you correctly, what you're saying is that the rule-making power conferred on the Supreme Court by Article 191 is law, but the source of law in respect of the word used over there, that's the source of that law is not the rule-making power. That law, the source of that law according to you is an act of parliament. So that's the distinction that you draw, but you recognize, you accept that the rule-making power conferred by the Constitution on the Supreme Court also creates law. The source of that law, the rules, is the Supreme Court, but the source of the law, the word as used in the preceding part, the source of that law cannot be the rule-making power. It is somewhere else, wherever that may be, but it is. Is that, have I understood?
Yes, that's right. My Lord, if I may now address the second part of it, the second question, which my Lord...
Forgotten the second question. You've forgotten the second question.
Then I have the convention bit. The convention bit, because some interesting question had arisen.
That was question number 1. As according to me, question number 2 was relating to 56 rules.
Yeah.
56 rules I have already. जी जी वो इस सारी conversation के अंदर back and forth.
Now you're back on, you're on the convention.
ये 56 के rules कौन से provision के तहत बने थे Constitution?
My Lord, 56 के rules
ने बनाए, the President hereby make the following rules.
Third schedule of 1956 Constitution उस वक्त बने थे sir.
हम नहीं, मगर इसमें लिखा हुआ है rule making powers with the approval of the President.
जी जो 1956 के rules है. Because उस वक्त
ये जो 1980 के या 191 के तहत
जी 191 के नीचे बने. उस वक्त 1956 के Constitution में approval required थी President की.
जो last rules बने हैं वो 80 में बने हैं ना हमारे. तो इसका मतलब ये है कि legislator has not performed his duty for 43 years.
नहीं ड्यूटी नहीं परफॉर्म की, उन्होंने आपको कहा कि आप बनाते रहिए, ठीक बना रहे थे.
अब उनको ख्याल आ गया.
ठीक बने हुए थे तो उन्होंने कहा कि ठीक चलते रहे. अभी आके उन्होंने कहा कि कुछ थोड़ी सी इंटरवेंशन की जरूरत आ गई है.
मतलब आपका कहना ये कि जब तक सुप्रीम कोर्ट सही चल रही थी तो उन्होंने चलने दिया.
मैंने तो फर्स्ट हियरिंग पे आपको कहा था कि अगर ये 70,000 पे पेंडेंसी चली गई तो शायद एक और लॉ की जरूरत पड़ जाए. अगर ये 20,000 पे आ जाए तो वो कहेंगे बैक ऑफ, पीपल विल नॉट अप्रूव ऑफ इट. हमने 5 साल बाद लोगों के पास जाना होता है, लोग हमें नहीं अप्रूव करेंगे.
जरा प्लीज आए ना, अपने बिल को जरा देखें.
वो रिकॉर्ड लाए हैं आप, जो कितने लोग थे, कितनी देर इसकी बहस हुई, कितने लोगों ने.
वो रिकॉर्ड पे आगे ही नहीं है, वो वेबसाइट पे भी थी, वो मैंने वैसे प्रोवाइड कर दी थी.
आप जब आप बात कर रहे हैं पार्लियामेंट की, तो पार्लियामेंट में एक बिल आया है, बिल के साथ स्टेटमेंट ऑफ ऑब्जेक्ट्स और रीजंस उन्होंने दी हैं. जो आप कह रहे हैं कि सुप्रीम कोर्ट में शॉर्ट कमिंग्स थी, लेट मी बी पोलाइट, शॉर्ट कमिंग्स थी, एक्सरसाइज ऑफ डिस्क्रेशन, एक्सरसाइज ऑफ ज्यूरिसडिक्शन, जिसके बेस पे आपने ये लॉ इंट्रोड्यूस किया. सो देयर इज अ स्टेटमेंट ऑफ ऑब्जेक्ट्स एंड रीजंस. जरा वो पढ़ लेंगे.
माय लॉर्ड पे विद
हमें भी
I'll read it for you. ये है, whereas the exercise of original jurisdiction of the Supreme Court under Clause 3 of Article 184 of the Constitution has been a subject of discussion by various forums with respect to invoking suo motu power, constitution of benches, and the absence of right of appeal. And it goes on. Now come to Section 2 of the Act. यानी आपका जो ग्रीवियंस था, चलें हम कह देते हैं, लेट्स टेक इट, चलें ठीक है, was suo motu and 184(3) कि उसमें अपील नहीं थी, jurisdiction एक्सरसाइज हो रही थी. अब आप आए ये 2 को देखें, पढ़े जरा आपने जो एक्ट में लाए हैं, पढ़ें.
Every cause, appeal or matter before the Supreme Court.
यहाँ पे रुक जाएं. Why the overkill? Why? देखिए, आपका जो कंसर्न था पार्लियामेंट के पास, चलें हम ये भी ग्रांट कर लेते हैं, पार्लियामेंट के पास पावर है, चेक्स एंड बैलेंसेस हैं, हम गलत कर रहे हैं, आप ठीक कर लें. तो आप वो चीज़ ठीक करें जिसका आपको ग्रीवेंस था. आपने तो पूरे सिस्टम को आपने टच किया. वाई डिड यू, इफ़ यू लुक एट इट, देखें चीज़ों को एकदम से सारी की सारी चीज़ों को ऊपर नीचे करना, पॉलिसी वाइज भी गवर्नमेंट के लिए, पार्लियामेंट के लिए, उनका देखिए उनके पास पावर है, लेकिन उस पावर को आप कैसे एक्सरसाइज करते हैं वो भी आपने देखना होता है ना. एक पूरी इंस्टीट्यूशन है, इट्स अ फुल सुप्रीम कोर्ट, इट्स एन एस्टैब्लिशमेंट, इट्स अ टाइटैनिक, यू कांट जस्ट टर्न इट अराउंड के इस तरह आप टर्न करें. आप स्टार्ट करें, एक छोटी चीज़ दें, बोले चले 184(3) को, और दूसरा है 186 जिसमें अपील नहीं है, रेफरेंस आ जाता है. आप उस पे स्टार्ट करें, देखें हम कैसे, हम नई चीज़ होएगी, स्लोली एंड ग्रेजुअली हम करेंगे. अगर ठीक नहीं चल रही फिर आप औरों के लिए, शायद हम खुद उन चीज़ों में आ जाएं. आप देखें, आपने तो इवन एन एप्लीकेशन, कोई मिसलेनियस एप्लीकेशन भी आया, उसके लिए भी आपने 3 लोगों को वहाँ कर दिया. तो थोड़ी ये पार्लियामेंट को भी देखना चाहिए. अगर गलतियां यहाँ पे भी हैं तो उधर भी देखना चाहिए कि जब आप चीज़ कर रहे हैं तो आप किस एक्सटेंट तक जाते हैं. ठीक. नाउ प्लीज कैरी ऑन विथ योर आर्ग्यूमेंट्स.
My lord's observation.
एजे साहब, अगर आप इसको इस तरह नजर में देखें, ये रूल्स आर सब्जेक्ट टू द कॉन्स्टिट्यूशन एंड लॉ. जब 80 के रूल्स बने, लॉ नहीं था. और जब कॉन्स्टिट्यूशन में कहीं ये नहीं बताया कि हु विल कॉन्स्टिट्यूट द बेंचेस. तो ये क्या ज़रूरत महसूस हुई कि अब आपको याद आया कि कॉन्स्टिट्यूशन मेकिंग बॉडी होनी चाहिए, बेंचेस की कॉन्स्टिट्यूशन की कोई बॉडी होनी चाहिए, क्योंकि न तो कॉन्स्टिट्यूशन में था, न उससे पहले कोई लॉ था. रूल में तो हमने दे दिए, लेकिन रूल मस्ट बी सब्जेक्ट टू द कॉन्स्टिट्यूशन लॉ. क्या वो जो रूल्स में बताया गया कि चीफ जस्टिस कॉन्स्टिट्यूट करेंगे, ऐसी कोई प्रोविजन कॉन्स्टिट्यूशन में है गिविंग पावर टू द चीफ जस्टिस और टू द सुप्रीम कोर्ट कि वो बेंचेस बनाने के इख्तियार किसी एक शख्स या फर्द वाहिद को दे?
Nothing on this matter in the constitution.
आप कहते हैं कि ये लॉ जब आया, नाउ सब्जेक्ट टू दिस लॉ बेंचेस इस तरह कॉन्स्टिट्यूट होंगे.
The constitution does not obviously deal with the subject matter, at least to the extent of sections 2, 3 and 4. Obviously the constitution does not provide any procedure in that sense. So my lord, I'd just move on to now the question of whether the conventions, because there was a question that because of the convention, because the long-standing history behind the Chief Justice being masters of roster in the Indian subcontinent starting 1861 and so on, therefore it has the same status as that of constitutional provision as held in Malik Asad's case, and therefore this act was ultra vires. This is a submission which was made, and my Lord Justice Munib Akhtar also had
Can I just ask a question out of curiosity?
On this or something else?
Related to this, that there's a lot of emphasis on the rule-making power and the rules saying that the Chief Justice will constitute the benches, which necessitated the formation of this committee. So does that mean that the rest of the rules are all right and nobody has any issue with them? There's no need for any interference, there's no delay being caused because of those rules, there's no need for anything extra, everything else is fine. It's just this one particular rule that is bothersome, and that is what is coming out of this discussion. Because as was mentioned yesterday, even to the extent of who will call a full court, it's not in the constitution, it's not in the rules, there's ambiguity, and there's been a lot of discussion about how a full court has not been called. Even you didn't think that that was also something necessary to regulate? I'm just trying to understand that where did this emanate out of? Only one issue has been highlighted in the entire set of rules.
Not just one, I mean the non-fixation of applications where urgency is sought. I mean, it takes months at end, the matter doesn't get fixed. You know, I can tell you from my experience at the bar, I mean, we file applications for early hearing every month, and you know, there have been instances I had pointed out, people in jail appeals, when they came up for hearing, people had already been executed, this court acknowledged it. So it is not that you know, there is this act only addresses the question of master of roster. There are other aspects also.
The provisions of this act are mandatory or directory?
So it has a mandatory effect.
It has a mandatory effect. So if something that these rules, this act requires the Supreme Court to do, and for some reason it is not done, what is the consequence?
Consequence
may be considered at the relevant time.
That is one.
Please answer the question.
That is one. And two.
नहीं देखिए बहुत से कानून में ऑलरेडी एग्जिस्ट करता है, ठीक है. अब हम कोई एटीए का केस उठा के बाहर तो नहीं फेंक देते हैं कि जी उनने एक मियाद लिखी हुई है कानून ने उधर जाएं, तो वो हमें हर चीज़ देखना होगी कि डायरेक्टली कॉन्सिक्वेंटली वो पर्टिकुलर केस कैसे है, हम जनरल ब्रॉड पैरामीटर्स कर दें. तो मेरे ख्याल में अगर इसमें मैं सिर्फ जो पॉइंट लास्ट डेट पे आपको कहा था उसमें अगर पार्लियामान चाहती तो एक कदम ज़्यादा जा सकती थी. वो कदम उन्होंने उठाया नहीं, और शायद इसलिए नहीं उठाया कि उनको हम पे एतबार है कि इसको हम खुद कैसे चलाएंगे. ये भी तो आप कह सकते हैं ना कि अब हम कहते हैं मैंडेटरी, आप लफ्ज़ इस्तेमाल कर रहे हैं मैंडेटरी, तो उसका कोई इसमें तो तस्करा ऐसा हो नहीं रहा है ना, उसमें कोई कॉन्सिक्वेंसेस दे रहे हैं. तो रूल्स ऑफ जितने इंटरप्रिटेशन हैं वो तो आपके ख़िलाफ़ जाते हैं. बट ये कह करके कि डायरेक्टरी और ये कानून का कोई मकसद ही नहीं है, ये भी शायद गलत हो. तो हमें देखें एक इदारे को दूसरे इदारे की इज़्ज़त करना चाहिए. यकीनन मेरे ख़्याल में पार्लियामान ने सुप्रीम कोर्ट की इज़्ज़त की और रखी कि भाई ये कानून तो हमने बना दिया है मगर इसमें आपको उस तरह से मैंडेटरी में पाबंद नहीं किया है. अब आप की भी दानिश है, आप लोगों की अकल और सोच है, आप देखेंगे कैसे चलता है. हो सकता है इसके अलावा भी रूल्स बनाने की ज़रूरत पड़े. तो वो मेरे ख्याल में अगर हर चीज़ का हम आज ही जवाब दे दें तो कल हमारे पास जो केसेस आ जाएंगे एक्चुअल केसेस, तो वो फिर तो हम पाबंद होंगे अपनी इंटरप्रिटेशन पे.
रूल्स के अंदर आपने ये एक्नॉलेज और रिकग्नाइज किया हुआ है. ऑर्डर 11 बिगिंस विद by saying save as otherwise provided by law. तो ये आपकी एक्नॉलेजमेंट है फुल कोर्ट की उन रूल्स के अंदर कि अगर कानून कुछ कह रहा है तो आप उसको.
What's the response of the federation, official response of the federation? You are the chief law officer of the federation. To the question that I just asked. What's your official response to that?
My lord, if the Supreme Court chooses not to follow the law or not to bring its rule in line with the law,
will it not be a violation of the
we will pray.
Violation of oath?
Your oath actually requires you to act in accordance with the Constitution and the law. So I think we would be venturing into that territory which I
General, please read para 2, section 2, subsection 2
of this act.
Yes, sir.
Ji, sir. Soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure, including...
Procedure still has to be framed by the committee in view of the full court, because all matters are mentioned in section 2.
My lord, committee ने मेरी दानिश में
प्रोसीजर तो कमेटी ही बनाएगी ना.
कमेटी ने मेरी दानिश में,
पहले बात सुन लें.
माय लॉर्ड, आप मेरी भी जरा सुनेंगे तो मैं जरा बात एक्सप्लेन कर सकूंगा. कमेटी ने मेरी दानिश में, क्योंकि सवाल मैंने समझ लिया था, कमेटी ने ये नहीं करना कि बाकी प्रोसीजर को टच करना है. कमेटी ने ये करना है कि हमने मिलना कब है, जुमे को मिलना है, हफ्ते को मिलना है, कॉल लिस्ट बनानी है, किस कैटेगरी के केसेस कहाँ जाने हैं. दिस इज टू माय माइंड व्हाट द कमिटी इज.
रूल्स में भी यही कुछ है और क्या है रूल्स में? यही कुछ है.
रूल्स में तो ऐसा कुछ भी नहीं है.
बता दीजिएगा ये प्रोसीजर जो है,
तो ऐसा कुछ भी नहीं है.
दिस प्रोसीजर इज इन द कॉन्टेक्स्ट ऑफ द कमिटी और द सुप्रीम कोर्ट.
कमिटी सर, कमेटी ने फंक्शन करना है. इट्स मोर देन वन पीपल हु आर गोइंग टू मीट, सो दे वांट टू वर्क आउट देयर
रिक्वायर्ड टू डिटरमिन इट्स मीटिंग्स,
मीटिंग एंड कॉन्स्टिट्यूशन ऑफ बेंचेस. सो वो जो आपने
देखिए, अब देखिए वी आर एक्सपेंडिंग द स्कोप ऑफ द चैलेंज. द स्कोप ऑफ द चैलेंज इज दैट दिस law is unconstitutional. Now we are going into how we will interpret, and I don't want to observe anything in the whichever judgment is delivered, how, if the law is upheld, how it is to be. That is up to, at the relevant time, appropriate body, whether it's a full court, whether it's a committee. We will certainly not accept or even consider what you say. We will determine that ourselves. Yes. So let's not go into uncharted waters. It's simply an attack has been launched on the act on its basis of its constitutionality, how it will work, whether it's functional, whether it's unworkable. It may require additional input from the committee or from the full court, are matters which I don't think we want to hear even from you, because we're not asking assistance. If a problem arises in a case, it may come, we may issue you notice under Order 27 to come and please assist us on that score. So let's restrict the scope of this thing. And I think the fundamental point जो हम लोग बार बार भूल जाते हैं, वो दुनिया जो है ना, वो एक दूसरे के साथ मिलकर चलती है, एंटेगनिस्टिक नहीं चलती है. ये जो पार्लियामान ने हमारी दुश्मन नहीं है, और यकीनन पार्लियामान हमें नहीं समझती हम उनके दुश्मन हैं, तो दोनों को साथ भी हम चला सकते हैं कि नहीं मेरा इख्तियार और तुम्हारा इख्तियार. ये दुनिया चलती है ना, उनके बड़े बड़े इश्यूज़ हैं, क्लाइमेट चेंज हैं, लोगों के हकूक़ हैं, हम इस बारीकियों में फंस गए, क्या क्या हो रहा है दुनिया में, और दुनिया आगे जा रही है और हम लोग बस इस ऐसी बाहर बहसों में पड़े हुए हैं. हम एक दूसरे की कदर, हम क्यों उनको मनफी तरीके से देखें. हम कह सकते हैं हाँ आपने कानून नेगेटिव इम्प्लिकेशन दें कि आपने गलत किया. भाई शुरू तो करें इस बात से कि आपने सही किया है, हाँ इसमें कोई गैर आईनी बात है वो हम देख लेंगे, उसको यहाँ तक ख़त्म कर दें. तो इतना हमें लड़ाने की कोशिश ना करें एक इदारे को दूसरे इदारे से. मैं तो कहता हूँ अंग्रेज़ी में, पता नहीं उर्दू में कैसे कहेंगे, लिव एंड लेट लिव. और अब इसकी बस हम देख लेते हैं, कॉन्स्टिट्यूशनैलिटी देखना है, बस इतनी सी बात है. अब हम वो इंटरप्रिटेशन हम लोग कैसे करेंगे, भाई हमारी मर्जी है, अब वो वक्त आएगा कर लेंगे इंटरप्रिटेशन. थोड़ी बहुत अकल समझ है, 40 साल से ज़्यादा वाबस्तगी है कानून से, कुछ ना कुछ समझ आ गई है, तो अब हर चीज़ हम लिख दें कि ये मसला आएगा तो हम यूँ करेंगे और ये मसला आएगा तो यूँ करेंगे, तो फिर तो ना कमेटी की अहमियत रही और ना वो फुल कोर्ट एडमिनिस्ट्रेटिव साइड पे उसकी अहमियत रही, क्योंकि अब फुल कोर्ट का जजमेंट आ जाएगा. फिर तो बिल्कुल आपने हमें पाबंद कर दिया और हमें स्ट्रेट जैकेट में डाल दिया. उधर हमें ना ले जाइए, आप सिर्फ फोकस रखिए आइन पे जो अटैक हुआ है.
My Lord. Grateful. My Lord, now to constitutional conventions, if I may begin my submission on that. My Lord, my respectful submission is that our constitution in its text does not recognize any convention. It does recognize customs or usages having force of law, but not the conventions. And I say this because conventions in historical sense,
Article 8.
Article 8 clause 2 and then Article 203B in federal Sharia courts is clause C, which also uses the phrase customs or using having force of law. I'll come to that in due course. What are those customs or usages which have force of law? I refer to a statute of 1872. My Lord, the conventions are a feature of an unwritten constitution, which is that of the United Kingdom. It is acknowledged by the English courts that the constitution, the conventions may be, the reasons for having those conventions or acting upon those conventions may be so strong that not acting upon them might elicit response from the people. But the conventions by themselves do not abridge the Parliament's power to legislate to the contrary. And if so done, the courts cannot hold them unconstitutional. I will, there are two judgments to the contrary what I am submitting. In Al-Jihad Trust case, this court held that they do attain a status of law and are enforceable by the courts. And in Malik Asad, they go a step further and say that conventions established over a period of time have the same status as that of a constitutional provision. My Lords, and with the benefit of addressing the full court and those judgments not having the binding effect, if I may take your lordships to the critique of the two judgments by late Justice Fazil Karim in his book titled Judicial Review of Public Actions, Second Review, Volume 1. I'll place the copies before you, Lordship.
Judicial Review of
Public Actions.
What edition is this?
My Lord, this is second edition.
I think he was one of the finest writers of Pakistan law. Each book is, I've always gained a lot from reading Justice Fazil Karim's books.
Volume and
page 95. This is volume 1, my Lord, page 95. I placed photocopies of the relevant pages for your lordship. Page 95.
The skill was to explain complicated things simply.
Absolutely.
95.
95 now towards the bottom, my lord. The last paragraph, but I'd start with the last, the second sentence. It was settled. Page 95, sir.
Last line.
Ji, last line. 95, last line. It was settled in Federation of Pakistan versus United Sugar Mills Limited, PLD 1997, Supreme Court 397, that the expression law means positive law, that is to say, a formal pronouncement of the will of